there. So good afternoon, everybody, and welcome to our presentation and virtual roundtable discussion this afternoon on the hybrid workplace from haphazard to intentional. My name is Amanda Nash. I'm a lawyer in the St. John's, Newfoundland office at McInnes Cooper. I'll be presenting today alongside my colleague Michael Murphy from a lawyer in the Halifax office. And before we start, just a couple of housekeeping items. So I'm told by the organizers that all mics will be muted during the session. However, you can contribute to the discussion by sending us questions in the chat box. The organizers will collect those and we'll read them out as time and opportunity permit, which we hope to have lots of time there at the end. We'll try to get to you, as many of you as possible. Some people submitted them ahead of time, which we will address as well. And if you don't get to your message, we will try to reach out to you individually after the session to make sure that your answer gets or your question gets answered. So, if you just want to go to the first slide there, I guess the second slide. Yeah, if you change, there you go. Okay. So the title of the presentation is From Haphazard to Intentional, because really when the onset of COVID happened, the real remote work from home movement was haphazard. So technological advancements had been occurring for a long time. Technology, laptops, mobile devices, and IT advances allowed you to connect to your workplace remotely. Some people did it for convenience, some people did it out of necessity, but it was a very minor aspect of employees, bulk of their work. And so when everyone went to COVID, it was, almost overnight, everyone converted to remote. Some, organizers didn't, or organizations didn't even have laptops, and people, very quickly, they had to get the technology out, and people started working from home, lots of people from their kitchen tables, and it really was a haphazard situation. Not ideal by any means. That carried on for a period of time. At various points during COVID, people went back to the workplace, then came home again, went back. As you can see here today, both myself and Michael are both still working remotely. Maybe one of us should have went to the office and we would have been a hybrid model as well. But while everyone, in our workplace is certainly welcome back to the office, a large majority of people choose to work from home. Some more than others, but their employers now, it's a frequent question that we're getting is, living with COVID, what do we do? Now that everyone has experienced the haphazard remote work experience and they settled into it, employees like it. Some do, some don't. Employers like it, some do, some don't. And we're getting questions now that some, from employers that employees don't want to come back to the office. What do we do with those people? We're also getting questions from employers saying, we like having a smaller footprint. We don't necessarily want everyone to come back to the office. We realize that people can be very productive working remotely, and that works for a business. It increases work-life balance, and it's something that we want to do. But while during the haphazard stage, people weren't as focused on the legal consequences or risks, things that they needed to be considering. They just, went right into a full-on work from home situation. Now, as it's becoming a more permanent, go forward even past the requirement for people to work from home, we're advising people and we're fielding a lot of calls around what are the legal consequences, what do we need to do, what do we need to put in place, how do we make sure that we can change our mind if it doesn't work out long term, what is that we need to do. So next slide. When we talk about the hybrid workplace, it means different things to different people. Some employers, their operations are just such that their employees can't work from the workplace or can't work outside the workplace. They need to be there physically. other organizations, there may be certain positions who can't work remotely. There are some people who've gone completely remote, and so there are varying levels of hybrid. It may be where some people work in the office full time and some people work home full time. It may be that all employees have the option to do some days in the office, some days at home. It may be that employees can choose where they want to work when they want to work, which would probably be the most flexible type scenario. So what it means to have a hybrid workplace really depends, and how hybrid you want your workplace to be, can be set out in your policies, but it's really a business decision what works best in your organization, what your employees want, and what you may have to offer in order to retain or attract employees. It's if you are on LinkedIn and you follow some of the trending topics, there's a lot of conversation around the hybrid workplace, and what employers think may be different than what employees think, and it's even come to my attention that when people are recruiting now on the job advertisements, you can filter now by remote work options. So some people, employees who've decided they like the remote work, they are actually seeking opportunities if their employers don't offer the flexibility to have remote work. So it right now it is on the forefront of the evolving workplace, and I think it will continue to do so, like COVID and vaccination policies and all the other things that have come along with COVID. Your hybrid workplace policies will continue to evolve, and what remote work looks like in your organization will continue to evolve as well. So even what we say today may not be what your hybrid workplace is going to look like in a year, but you have to be flexible. But in doing that and laying the groundwork for it, there's a number of legal considerations that we want to discuss for you to be aware of. So next slide. So this one is just kind of out of interest, just out of curiosity. We have, I looked at some statistics. Some of them aren't very recent. You also have to look at the source of them. So there was someone had asked a advanced poll question about how many employers going forward in Canada do they anticipate to have a remote or hybrid workplace. And one statistic I looked at was from a poll done by KPMG. It said that 43% of Canadian CEOs who were polled in that poll, which was a good bit earlier this year, had indicated that at least 2 days a week going forward, they anticipated having people work from home. I'm not sure of the real, whether that included workplaces who really it wasn't conducive to hybrid work. But so we have this poll here. The results are in there now. And it's that 6% say they've long had a hybrid work model. 63% say they started during COVID and intend to continue. 13 started during COVID but don't intend to continue. And then the 19% where the workplace isn't conducive to hybrid. So, I mean, that's probably fairly representative of some of the other statistics that I've seen. But on the flip side of that, there are a lot of polls on LinkedIn requesting what employees are looking for, and you either you do the thumbs up if you want to work from home completely. You may do a clap hand response if you want to if you intend to go back to the office full time. And so there is some discrepancy between employee expectations versus employers still. So it'll be interesting to see where we all land in another year and a half or so. But Michael's going to take over now and set out the legal framework as to what you have to be aware of when you're considering and continuing to evolve your hybrid work scenario.
Hi, everybody. Thanks, Amanda. So I'm a lawyer in McInnes Cooper's Halifax office, And I've actually mostly been back in the office for quite some time now. Time is all a blur since March 2020, so I can't tell you when I sort of returned. But as you can see, I'm here today in my basement bunker dialing in, but not because of a personal preference. My kids are having a PD day, so here I am working from home. But what I found interesting from that poll and the results there, 63%, adopting this and saying, hey, we're going to kind of continue with that. I think, speaking from my own experience, I think we saw, kind of had our eyes open, I guess, to the realities of being able to work from home. And I know certainly before COVID, a PD day and the thought of having to work from home and do a webinar would have been, no, that's impossible. We'll have to find childcare. We'll have to do something else. This isn't going to work. That is no longer, kind of a barrier to entry there. And I think obviously, what that poll seems to reflect that as well. Still early days. Interesting to see kind of how things continue as we progress through the pandemic. But I do think that's sort of telling as to where things are trending. And the other quick anecdote I wanted to share is that I gave a presentation for CPHR Nova Scotia just a couple days ago, and it was the first in-person presentation I've done, since March 2020. And so it was very interesting to, once again, be in a room and actually see participants' faces. So hopefully we'll be able to start doing more of that ourselves with time. But great that we can make use of the resources that we have. So as Amanda said, we're going to talk about some of the legal considerations that are at play right now, and the three sort of primary, areas or kind of headings that we're going to be looking under are statutes. So what do the applicable employment statutes say, and how do they govern? And then we'll talk about policies in the workplace, either existing policies or potentially new ones that you may want to put into effect. And then we'll finish by talking about how this affects the individual contract of employment. Change the slide. So the first up would be statutes. And if you could flip ahead again, please. So this is an interesting question, and I think it's one that, really bears, close consideration, because I've had, multiple people call me saying, hey, we've got a new employee. We want to prepare an employment contract for them. And, the first, previously I would have just assumed, okay, it's probably a Nova Scotia employee because it's a Nova Scotia company. If you're in New Brunswick, probably a New Brunswick employee. But more and more now, people are actually hiring remotely, and taking it as a given that the position will be remote. And so instead, they're saying, no, actually the person's based in Toronto. And sometimes the company isn't even in Nova Scotia; they might be in British Columbia. And so the question that brings up is, which jurisdiction will apply? And so you've got to be careful on that, because if you're in Nova Scotia as a company and you're hiring an employee in Ontario, Nova Scotia law does not presumptively apply. The law that applies is the jurisdiction in which the employee resides and works. And so if the person is in Ontario, you've now got an Ontario employee, and you might have just been getting used to the Labor Standards Code and how it operates. But with that one Ontario employee, you'll have to ensure that you're abiding by the Employment Standards Act in Ontario. And equally, I'll talk a bit about contracts later, but you'll have to be sure that your contracts are reflecting that. Now, it is possible to have a jurisdiction clause in a contract where you've, say Nova Scotia law will govern, but minimum employment standards, you can't contract out of those. So however that gets addressed, you've got to keep that in mind. So the usual suspects here for the list of employment-related statutes, and the question being, how do you ensure you satisfy all your obligations in that remote setting? And so the different statutes: occupational health and safety, workers' compensation, employment standards, human rights, and tax. And so I'll just start with OHS and WCB. So under the Occupational Health and Safety Act, obviously the act wasn't drafted with the remote workplace or telecommuting in mind. And so what the act refers to is simply the workplace, and that leaves it open to interpretation as to whether it is meant to cover somebody who's doing work while they're at home. But these acts are, like all employment statutes, the Occupational Health and Safety Act is given a broad interpretation. And so, very likely that it would be interpreted to cover work at home. The one sort of caveat there is, for those of you who are in New Brunswick, the New Brunswick legislation does have a carve out and exempt somebody who's working from home from application of the act, which in a way makes a kind of a sense, because if you're working from home, how much control can an employer reasonably exert over the safety of their employees' home environment? But without that specific carve out in the legislation, and the fact that it's in one provincial statute but not in the others, would be an indication that workplace would be interpreted broadly. And so those usual requirements would apply. And so under OHS, there's an obligation on employers to take every reasonable precaution to protect the health and safety of employees. And then there may also be some specific rules that need to be followed, like ensuring there's a first aid kit on hand, and so on and so forth. So these are some of the things that employers have to keep in mind, and to ensure that health and safety is being followed. So, whether that's somebody sitting at a desk, if your normal process would be to have, somebody come and do an ergonomic assessment, if they're in the office, then a similar approach should be followed if they're now going to be working from home, and that's something that is, specifically a part of their employment that's being contemplated. And so, whether that's sending somebody in to do the assessment or having some form of a checklist that you ask employees in doing their own due diligence. Obviously, the more involved you are in ensuring that home environment is safe, the better off you'll be if there happens to be an accident or an injury. And employees need to know that they have to report any kind of accident or injury that occurs while working from home in the course of their employment. Somebody did raise the question of, what if there's an accident? Do we have to conduct an investigation? And my sense on that would be yes, because if it's a workplace and something happens, it should be reported, and you should follow your normal processes in order to properly investigate that. And when Amanda talks about policies, I think that's one of the things to sort of take a relook at when looking at occupational health and safety and those rules, to make sure that employees understand that if they are going to be working from home, that this is something that may happen. This is a part of it, comes with the territory, to expect that your employer may need to do this at some point in time. The other wing on the health and safety side is WCB. And so to go back to that earlier example of the employer in Nova Scotia who has an employee in Ontario, you've now got an employee in Ontario, and the rule in Ontario is one worker, and you've got to register, and it's not a choice, it's mandatory. So you have to know that, and you've got to be ready for that, and ensure that that you're properly registered with the appropriate authorities in whatever province you happen to be employing people in. And different provinces, have different rules on that. I would say, Amanda may jump in at any time, and I may jump in when she's talking at any time. And so, Amanda, feel free if there's anything you want to add to these different points.
Yeah, no, you've said everything good, and I will touch on some of that again when we get to the policy section. But I'm queued up to talk about employment standards, and so Michael already alluded to the fact that you have to maintain the minimum employment standards, and you cannot contract out of those. And the onus is on the employer to ensure that they know what they are and to follow them. Um, you can. There is often a jurisdictional clause which may prohibit in a contract, which Michael will talk about, in more detail later. You can try to contract out of the jurisdiction, say that any claims or any disputes when it comes to a court process or an arbitration may be done in accordance with the laws of, Nova Scotia or Newfoundland, one that you select. However, when it comes to employment standards, since you cannot contract out of them, even though you may have a jurisdictional clause in your contract, there's nothing in that contract that would prohibit an employee from filing a complaint with the Employment Standards or the Labor Standards Division in the respective province that they work in. So it is very important for your HR, payroll personnel to ensure that they have an understanding of what the employment standards are in the province in which you are going to allow an employee to work remotely. This can be burdensome for small employers who have employees working in multiple different jurisdictions. So some employers, some clients that I have set up a system where they can allow people to work from British Columbia, Ontario, New Brunswick, or Newfoundland, but they and we'll talk about that kind of when we get to tax. Is that they cannot accommodate work from Quebec because their system for taxes and things like that is so different that it's not an option they want to offer. So you can be specific around which provinces you are willing to permit remote work around, and then your HR personnel, your payroll personnel can become acquainted with one or two additional employment standards regimes instead of having to be aware of them all, because not only is it a one-time crash course, you have to keep up to date with changes that are happening in those jurisdictions. So the big things you want to be aware of with jurisdictions or the employment standards in various jurisdictions is it touches on public holidays, entitlement to vacation, it touches on the overtime requirements and how many hours are in standard working weeks. So those things can vary, even though slightly. They are different across jurisdictions. So, while you may have an employee in New Brunswick off on, or Alberta on family day, there's a public holiday, family day, or something like that in Alberta. Whereas I'm willing to bet that there is no holiday in any other province that we have in Newfoundland. It's Regatta Day. That's dependent on the weather. That seems absolutely absurd to employers in other provinces that their employees working remotely from Newfoundland could have a weather dependent public holiday. And how do you manage that? With respect to the expectations of your clients when someone may be available in one province on a certain day, but an employee is not accessible in another province because they are entitled to observe that holiday in their province. So the rules do differ. And when it comes to overtime and hours of overtime in Newfoundland, and I think in the majority of provinces, the overtime threshold is under 40 hours. Michael, I think is it 44 in Nova Scotia?
48.
48. Okay, so there you go. I
Yeah,
mean, that's huge. If you're a Nova Scotia company and you don't think you have to pay overtime until employees exceed 48 hours, they
yeah,
may not want to have their employees working in other provinces where they're going to have to pay the overtime after only 40 hours. Maybe why they want a lot of employees working in Nova Scotia, that they get the extra few hours out of people without having to pay overtime. So those are things that you have to really be aware of. Whether the threshold for vacation, whether they get 2 weeks, 3 weeks, 5 weeks, and at what intervals. So really, I mean, this will impact all of your policies. And it can be complex if you are allowing people, like individual employees, to work in various jurisdictions. So those are things that you have to be aware of. The other thing is that you have to keep accurate records. And so when it comes to hours of work, there may be specific recording requirements when maintaining records in accordance with the labor standards of your province. And so, again, I'll talk about this a little bit more when it comes to the policy part, but you have an obligation, at least in, most, although they vary, as to how many hours people are working and to record that. And so you're going to have a policy in place to ensure that you can meet the obligations you have under the employment standards legislation.
Yeah, and I think that's a great point. Before I talk about the human rights piece, it's that I think previously would have felt like we had more oversight over the amount of hours that employees were working because they were in the office, it's visible. There's a bit less of that, obviously, when somebody is working from home. And so putting some kind of mechanism in place to track those hours accurately, ensure that employees aren't, voluntarily working overtime and potentially making a claim after the fact to say, oh my gosh, I was working 60 hours a week that whole time. You guys, I thought you knew. And now there's all this extra time and a half that I'm supposed to be paid. And so accounting for that is, I think, one of the key things as well. And so on the human rights slide there, so this is obviously in every jurisdiction, there is human rights legislation that has a number of protected grounds. And one of the interesting things that this trend towards working from home has sort of unleashed, for better or for worse, is of course, here I am today in a PD day, working from home, and I think it's kind of opened the door, and in the sense that previously an employee who said, I've got childcare issues and I'm going to be working from home for the next day and a half or 2 days or whatever it may be, that may have been something that an employer couldn't accommodate, and may still not want to necessarily accommodate on a regular basis. But once it's been shown that people can work from home, and unless there is an undue hardship to say we can't accommodate that and here's why, I think it's opened up the obligation a bit wider there, so that if you do have employees who are requesting to work from home, either on a permanent or a temporary or maybe a few days a week basis, you'll have to give that some serious consideration as to whether it's something that can be accommodated. And the usual, rule would be that they can't simply say, I prefer to work from home and I don't want to find childcare. It is reasonable to expect an employee to try to find childcare if that's warranted. But if they can't, then a work from home arrangement may be something that an employer would have to take into consideration and possibly allow. And so similarly, that accommodation rule isn't just for family status. Anybody with a disability, either physical or mental disability, may also wish to work from home on occasion. And so that's, again, another door opening in a way that employers will have to consider and ensure that you're complying with your statutory obligations under the Human Rights Act in following your normal process for considering any requested accommodation.
I will touch on the human rights piece as well when we get to policies. But I can't. There's twice now. Michael has mentioned working from home and doing a webinar with his children home on a PD day, and I think that's very dependent on your children. I certainly would not be able. While I do work from home, I work from home. I actually haven't been in my office since before I went on maternity leave in 2019. So I work from home exclusively unless I have an in-person meeting. Or have to go to a hearing or type function. But I certainly, even throughout the pandemic, I would not be able to work from home with my children present, or they would be in here on my lap. You would hear them in the background. Someone may call for help for them while they're here. So when we're talking about accommodation and what employers' obligations are, I mean, you can you may have a duty to accommodate when there are childcare obligations, but you still have a right. Michael is obviously getting his work done today, and so that's fine. Whereas that wouldn't, you don't have to let an employee, work from home but not actually get anything done. So those are individual type assessments. And as I'll talk in the policy section about, employees have to have a dedicated space. They have to be able to work from home. It can't just be, you're taking a sick day, but I want to be paid because my laptop is sitting on the table kind of thing. So
Yeah.
I'll touch on that again in the policy section. But before that, I'm going to talk about the exciting world of tax. I'm going to just put it right out there that, I'm not an expert in tax. If you had a specific tax question, we have colleagues who practice tax exclusively who would certainly be able to help you out on, some of this more specifics of what that means. But generally, as employment lawyers, we do know that when you provide benefits to your employees, some of them can be taxable, and you have to put a value on that benefit, and you have to record them as benefits, no different than you provide medical, dental, insurance type benefits, or other non-wage benefits. If there's a value to them and they are taxable in accordance with the Income Tax Act, you do have to record those and make specific payroll deductions to ensure that you're deducting enough tax to account for the additional benefits you're providing. So whether you're providing employees a reimbursement for expenses incurred, or you're providing them an allowance to ensure that they have, high speed secured internet, or if you're providing them an allowance for a telephone service or whatnot, or you're giving them money to purchase their own, ergonomic chair, which then will be their chair, and you're providing a reimbursement for that. Then you have to account for that. During COVID, I think everyone just took everything home. Some of that stuff is filtering back to the office, but on a go forward basis, you need to have policies around what you're going to provide, if there's going to be additional benefits or expenses that will become benefits. And employees need to know up front that those are going to be taxable, and that they will have to be, liable for the tax on that benefit, even though the employee may not see that as a benefit. The provision of electronic equipment that allows them to work at home may be a benefit, and likely is a benefit under the Income Tax Act, for which they would be responsible for the tax implication. So those are things also that you have to be aware of, and employees have to be aware of, before they elect to start working from home. Oh, and just before you get onto that, Michael, there was one, I just remembered the one piece about the
Yeah.
Quebec. So also when it comes, the other big piece that I mentioned earlier and then almost forgot about was the income tax. So the income tax levels and the tax forms that your payroll has employees fill out every year. So obviously everyone has a federal tax component, but the income tax that's provincially, attached to the provincial levels, the provincial income tax brackets, those would vary. I think they're a T something form, so they would be different for the different provinces, and as well as the contributions to different things. And so that was where the example I mentioned earlier about the tax system in Quebec is very different. And so I know of at least one, actually I think a couple of employers who've kind of put a policy on there that their payroll system is not set up to account for the tax differences in Quebec, and at this point they, so they aren't offering remote work there. So you would have to be aware and to make sure that you are deducting enough tax based on the different provincial tax components in each province.
Yeah, and so the next point there is about labor relations, and those of you who are unionized and have a bargaining unit employees. The point really just being that labor relations is provincial, and so every province has its own labor relations regime. And if you're operating in Nova Scotia and you have a bargaining unit that's been certified by the Nova Scotia Labour Board, let's say a bargaining unit of office employees, and one or two of those employees decide to, they're working from home and they decide that they're going to move to New Brunswick or PEI or something along those lines, then there's an argument that they've left the scope of the bargaining unit. They're now an employee in New Brunswick, and that bargaining unit description would no longer apply to them, and it would have no legal effect to them because it's an order of the Nova Scotia Labour Board, and it can't apply outside of the province. So that's the point there. Sort of a unique issue, but certainly for employers who may have employees spread throughout multiple provinces, something there to keep in mind, because they wouldn't, the employees as a group wouldn't be able to unionize with any one particular province. They would all, in their own separate way, have to apply and certify on their own within their province of residence and meet the applicable tests there. So just sort of an interesting one to flag.
All right, so next we're going to talk about the policies and procedures that you have to consider when you are, moving to or adapting to your hybrid work model that was haphazard and now is becoming more intentional. Many of the things we've talked about, the statutory obligations, are going to be reflected in your policies. And I've broken the discussion, over, 2 slides. One is to talk about amending your current policies. So you don't have to just implement new policies. Having at least a part of your workforce working remotely, it means you need to revisit all policies you have to determine if they are impacted by the fact that your workforce is no longer simply in one location. And then the other slide, and after we'll talk about specific policies that you need if you are going to have this going forward. So the first one is, you have to basically, take your employee manual, take your binder of policies, and just do a review, a rinse on them all, to the extent that any of them will be impacted by, people working remotely. That should be reflected in the policies. You don't want to have a separate book of policies for people who are working remotely. You want people to know what applies to everybody, regardless of where they are. So some of the ones that we're seeing that are, common in a lot of workplaces that have to be revised is, as Michael already mentioned, the occupational health and safety will be a big one. You have to review your legislation, see, what your obligations are and what you can do to reasonably, protect people, provide a safe work environment in their homes. It seems kind of silly when you're talking about you protecting people in their homes, but just as you would have an OHS committee go around the workplace with a checklist and make sure that, there's no trip hazards, there's no fire hazards, people don't have, too many things plugged into a power bar, you would want to almost, perhaps develop a checklist that you have employees conduct themselves and attest to the fact that they do this, or they're required to do a check of their office space every so often. Michael also mentioned, with OHS as well as, under workers' compensation, you may want to ensure that people are having ergonomic assessments and telling people, they have a right to get them, and that, they that they've attested that they've got an ergonomic workplace. Now, in your policies, you would say, we've done this stuff, and we want to make sure that you're using your workplace and that people aren't sitting on the couch or at their kitchen table, and that they have an ergonomic workplace, because it is possible, particularly during the early days of COVID, when people were just planking down anywhere with their laptop, that's looking for injuries to happen. So some employers, when they're looking at their policies and whether they're going to offer remote work, they may want it to be a requirement that employees have a dedicated workspace at home. If employees don't have a dedicated workspace at home, then maybe they won't. That's not something that's going to be available to them, because there's no way to ensure that they have a safe place to work, or that they have an ergonomic place where they're not going to, over time develop injuries for having an unergonomic setup. So that's one of the policies that you currently have an OHS policy that you'd need to review, revise, and roll out based on what your hybrid workplace is going to be like. Others may be accommodation policies or human rights policies. You likely already have those to some extent, whether they provide for accommodation or remote work as an accommodation. It may not have been something you considered before, and you would want to reflect that new reality there. And vacation policies. You may already have a process for applying for vacation, or it may refer to specific employment standards. If you typically were, only operate in one province before, your policies may reflect the labor standards that apply in that province that you typically work in. And so you would want to revise your policies to either specify the different jurisdictions that you have people operating in, or make some of the references more general, or put a catch-all phrase there that if you don't work in this location, then the labor standards apply, or if there's a conflict, defer to people's contracts or whatever. But you have to acknowledge the fact that if someone picks up the manual and they're working in Ontario, they know that the employment standards in New Brunswick, as it refers to in your policy, don't apply. Then we have the new policies. So if you are going to have a permanent or at least long-term remote work situation, you need special policies, and this is where people have the most questions. What do I do? How do we set this up? How do we protect ourselves from doing this? And to be honest, at this point, some employers don't even have an appreciation yet for the risks that are there with some of these things. So there's a few listed there on the screen. Like, you want to have your work from home policy, whether you're going to be hybrid. You want to set out for employees the scope of what your policy is going to be. That goes back to one of the earlier slides around, what is hybrid, and that can mean different things for many different organizations. So if you have a scenario where people can work 2 days in the office and 3 days at home, you would want to set out clearly, do employees have the flexibility to pick those days? Do they have to, select certain days and those be their permanent work from home days? Or do they have the ability to get up in the morning and decide? If they do decide, do they have an obligation to report that they're going to be working from home today? So you really need to give consideration to the parameters of your work from home policy and what the rights and obligations of employees who are selecting those options are going to be. Another huge one is data security. So if you, and this goes to the point that I made about having a dedicated workspace, it's very important in our line of work, but certainly in many other workplaces, employees deal with confidential information. They may have to take confidential phone calls, and you want to ensure that people have a dedicated space in order to ensure the confidentiality of the work that they're doing. You may want to ensure that they have a locked file cabinet, that they can keep any documents that they have. You may want to, update or require there to be more frequent, password changes on their electronics to ensure that or have a shorter timelines if they walk away from their computer, that they automatically lock. And you need to have these policies in place to ensure that everyone understands that, it's not just them personally who has to maintain the confidentiality. If they are deciding to take their work home and that's going to be their primary or even, part-time place of work, that anything that they bring home, they are responsible for ensuring the confidentiality of the things that they are doing when they are doing them, and where they are keeping them. The other thing is privacy. And this is employee privacy, employee monitoring type scenarios. So when, I mentioned earlier about needing ways to ensure that you can track your employees' productivity, their attendance, in order, to be able to determine whether this is, a working arrangement, that people are actually being productive, they are at their desk when they say they're at the desk, which may be a clock in, clock out system. It may be a technological function that shows when they're active on their computer. However, some employers want to go further to make sure that when they're active at their computer, they're actually doing work. So some of that employee monitoring, which you may have to do to ensure that people are actually working when they're supposed to be working, some of that has privacy implications. So, generally speaking, you can't, watch your employees through their webcam, although some employers think that's a great idea. Generally, that's not something you can do without the employees, giving them notice of it and their consent. And, most employees would likely be uncomfortable with that. Then there are other options, whether that's, recording, keystroke recording. So if at the end of the day, the IT department collects, everywhere they've been and records calls, and, with respect to the recording calls, unless you're a party to a call, it's actually, illegal to intercept a call. So, that's not recommended. Again, some employers think that's a great way that, unless employees know, if that's something you're going to do, you have to let them know, and they have to let the callers know that the calls are being recorded, for quality assurance, monitoring, training, whatever the reason it is that you feel the need to record that. And then the keystroke monitoring, as I also mentioned, that's the least invasive way. Is it necessary? That's something you have to balance in your workplace. I already talked about the OHS, so I won't really, harp on that. If anyone has any specific questions around it, we can talk about that. And yeah, I've already talked about monitoring too. So, are there any other policies that you can think of, Michael, that we haven't listed there or I haven't spoke of?
No, I think that covers it. I mean, things like, expense policies, and but I think you were touching on that with kind of
Yeah.
existing policies to make sure that it covers off, this newer sort of arrangement. I mean, it's always kind of good practice, I would say, to take a look at your policy manual and see what it says, because sometimes you'll be surprised to know, oh my gosh, the policy says X, but we've been doing Y for the past 5 years. How does that work? And updating that to reflect. And so, given this sort of general change, it's good to kind of look at those things anyway and see how you might want to adapt that.
Yeah, there is one more that I just also thought of, which we haven't, is around vaccinations and whether employees who work from home are required to be vaccinated. That's a more of a contentious issue. Might be it's almost a topic on its own, and it might be more better covered in one of the webinars that we've done on, or may have already been covered in one of the webinars we've done on vaccinations. So if anyone has any specific questions about that, but just very briefly on the point, I mean, some provinces have enacted regulations around remote work from home. Specifically in Newfoundland, we have COVID-19 vaccine regulations that state that certain industries, including employees who work from home in those industries, if it is such that other persons may enter the workplace in doing that. So if you're an at-home hairdresser, then you likely have to, anyone that you have work, your employees, including yourself, would have to be vaccinated, and you would have to, accept the vax pass of people entering your workplace. Whereas, in other policies, you may, your as an organization, you may have that you don't want your employees to have clients come to your house to sign documents or whatnot. And so you may want to set that out, what the parameters are around, other people coming to your house, and what that may mean from a legal perspective.
So the last sort of general bucket topic of the day is the contractual considerations that come into play. But Amanda did sort of twig for me there on the human rights side. Again, with mandatory vaccinations, you may have employees who say, well, I have a religious exemption from being vaccinated, or I fall within one of the very narrow exceptions. And so then the accommodation process, you'd have to sort of look at, well, what can we do And so if working from home is something that was previously allowed and you could do that, then you may have to consider that as an accommodation for those employees as well. But on the contractual considerations, so if we could just move ahead to the next slide, the question there is, does a hybrid arrangement create a new or revised contract? And, this is an interesting situation. I certainly think that if it's early enough, if it's a relatively short period of time and it's truly temporary, in the early days, for example, of the pandemic, people working from home, if within, 3 to 6 months, they were said, okay, we're reopening, time to come back, probably difficult for an employee to say, no, this is now a permanent thing. I get to work from home all the time. Likely wouldn't be able to make that argument. But the longer that somebody has the ability to work from home, the more they may come to view it as a part of their terms and conditions of employment. And so the more time that goes by with people either working from home fully or having a hybrid arrangement, the more difficult it will be if you don't have something in writing with them to change course and say, we're no longer doing that, or your duties will require you now to come into the office 4 days a week instead of 3 days a week, whatever that may be. It may be much harder as more time goes by to enforce that. An employee may reasonably say, no, that's not part of my job. I now, this is something that I get. It's like my compensation or benefits, and it's part of my terms and conditions. So what the risk there is the claim of constructive dismissal that could arise if you don't have something in place to address that, because the employee may very well say, well, or the employer may say, time to come back. If you don't come back, we're going to have to let you go. Obviously, that would be a termination. Or if they said you have to come back, and that's we're making that a requirement, the employee may reasonably be able to resign and say, you changed a term and condition of my employment without my permission, without my agreement, and tried to enforce it. And so I'm claiming constructive dismissal. So that's the risk. We can move to the next slide. And so what I would suggest is, obviously for those who are new employees, if a working from home option may be there, that in their employment agreement you would include something to address the possibility of working from home and what that looks like, with the goal of reserving the most amount of flexibility to the organization to decide whether those arrangements will continue, and to make it very clear in black and white that this is not something that is a key term and that it can be taken away at any time, so that you can avoid those kinds of issues. And so you'd want to have that addressed. The other, for current employees, you could just have a sort of a telecommuting agreement or a work from home agreement of some kind, or a protocol that they sign before they, you allow them to do that, which again would set out certain terms like, the ability to withdraw permission to work from home by the employer. You would want to set out similar to some of the points that Amanda was raising with the policies, and so you'd want to have something in an agreement that reflected what your policies were, to what their workplace, what they had to have for their workplace, addressing safety, data security, and privacy, whether they should have insurance, home insurance, to better ensure that you mitigate any risks of injury or anything that could happen, any kind of tort-based liability that could happen in the home. And again, the ability to end that arrangement with notice is key. And so all of these things, you'd want to have clearly set out and addressed in one form or another. Obviously, if you have it in a policy and then you also have a signed agreement where the employee is specifically saying, understanding what those terms are, then yeah, you'll be better protected. So, some of the other things that you'd want to maybe address there would be, what are the agreed upon hours of work, and how will hours be recorded? So to go back to that earlier point, in terms of self-reporting of hours, you'd want to make sure that there was a regime in place there, so that it wasn't coming to you, weeks or months after the fact when somebody is claiming that they've worked overtime, you want it to be fresh enough that you could review that and consider how to address it. So those are all of our slides, and we're coming up on the hour. So I guess I would open it up to any remaining questions. I'm happy to go past the hour if anybody has any questions and wants to continue the discussion.
Agreed. I think we underestimated how long we could talk about this topic, and I think we probably would have talked for much longer. But we certainly do want to answer some questions, and we'll stay, for a little while to answer as many as we can.
That's great, guys. We have some questions here that were sent in previously, and you may have addressed this, but we do have a question that's consistently coming up, and it is, of course, do employers have a legal obligation to assess the safety of each home work site, and what evidence is required to assess?
I mean, I can start on that one. Oh, you go ahead, Michael.
Go ahead. Oh, you go.
Okay. So, I mean, I don't think it necessarily goes as far as to require that, the employer employ a safety officer who does a home visit at absolutely every home office. However, you would want to have, that checklist that employees attest to having reviewed and done. You may want to reserve the right to have home visits. Depending on the nature of what they do at home. But that's going to be kind of dependent on how many people and the type of work that they are doing from home. It's certainly something you can consider, but at the outset, I wouldn't say that they have an obligation to visit all of them, as long as you've done your due diligence by telling employees what the risks are in a home office and what they have to look out for, and then having a form or something that they have to complete and submit periodically to make sure that they've that's fresh in their mind. Then I think that would be sufficient, unless Michael has any other thoughts on that.
Yeah, no, I agree. I think that's right. There's sort of scales, expectations of what you may have to do, and I think as at a minimum, for sure, you'd want to have them complete some kind of checklist and provide them with some kind of guidance about what you would expect their home environment to look like, free from distractions, no cables underfoot, that kind of thing. But ultimately, I think it's fair to leave it up to the employee to conduct that review themselves and to provide some kind of documented evidence that they've done that and confirmed it. And yeah, I agree as well on the kind of keeping it up to date so that they don't do it once and then, don't do it again for another 3 years or something.
Perfect. Thanks so much, guys. We've got another question here about employees working from the US. So are there any special considerations when we have employees working remotely from the US?
I mean, I think it's a similar issue as somebody working in another province, because they are, there's likely going to be, but maybe even more complicated, because they will have their own local laws that will apply. Obviously, I couldn't advise on what those laws may be, and I think sometimes there's federal laws and then there's also state-specific laws. There would also be income tax obligations that would differ, and it can be, I know from some clients that it can be a bit complicated if you have that one employee and you've got to be reporting to the IRS, and so there are certainly differences that would have to be taken into consideration if you're employing anybody in the U.S. or anybody outside of Canada, and you'd have to retain local counsel on that as well.
I would agree with all that for sure.
Perfect. Now we just had a question, a new question just come in. It's a scenario here. What if an employee was working at their dining table since the beginning, but now you consider that to be inappropriate since they could come into the office? So I guess we have an employee that's always been working remotely in this at home at their dining table, but now they have the option to come into the office. So
So my advice on that would be that, that's not a long-term sustainable. I mean, I think everyone at one time or another has sat at their dining room table with their laptop and done work. But when you're looking at a permanent work from home arrangement, there are a number of things that would go into that. And, unless there is a human rights accommodation that, absolutely requires that person to work from home, then they'd have to get into, is their dining room chair ergonomic enough or whatnot? But I think if the employee has the ability to come to the office, and it's a personal choice as opposed to an accommodated reason, then with in the absence of a private and ergonomic space that can be controlled, and you can it's that it's private where confidentiality can be maintained, etc. I don't think it would be reasonable for an employee to expect that they could continue to work indefinitely from their dining room table.
Yeah, and I think too, it's sort of, you got to go back to the sort of exceptional circumstances. I'm guessing it's since the beginning of the pandemic, not since the beginning of their employment necessarily. But it does go to that earlier point of, how long has it been going on? What is the reasonable expectation of the employee? Were they hired, when they were hired, did they think, let's take that, if it wasn't just they were working in the office and then they were work from home for the pandemic. So on that one, I would say, no, temporary issue, office closed, as long as the communication was clear, that I don't think the employee could reasonably say, this is now my job. I think it would be reasonable to say, we're now reopening and we expect everybody to come back, and, for whatever reason that you may have, then that's a fair requirement. Now, for somebody who may have been hired in the midst of all this and maybe believe that this was a remote work job, that could be different, because they could have a different expectation, and unless it was clearly communicated to them, hopefully in their agreement, that this was temporary and that they could be required to work from the office at any time, then that would be a little bit more tricky, and you'd want to check on those circumstances.
That's great. Thank you so much. And we've got someone that would like us to review the legal obligations around providing ergonomic furniture to employees when they're working from home. Just review that again.
Okay, so I mean, I can touch on it, and if Michael has any other thoughts as well. But I mean, there's no there's no obligation for them to provide ergonomic furniture if they have an alternative, to having ergonomic furniture in the office. So if it again comes down to whether they have an accommodation to stay from home. So in the case where an employee has an accommodated reason to stay from home or to work from home, then the employer may have an obligation to provide an ergonomic workspace. The risk of not providing the workspace is that the employee suffers an injury. However, any accommodation request is really an individualized assessment, and so you would have to look at that on an individualized basis. There may be reasons that employers do provide or want to provide, under the umbrella of doing whatever they reasonably can to ensure the health and safety of their employees. But it's not a legal requirement that they provide it, unless it's going to be a benefit of their employment, that they get an allowance for office furniture or something as part of their compensation. Again, those would then be taxable benefits. If they were provided, even though it's not money in their pocket, if it's a benefit that employees get, and they are providing it, the employer does have to value it and account for it as a taxable benefit. But I think that it's more of a general, or I can't really provide a general answer, that you have to look at the individual scenario and what the employer wants to provide in order to combat the risk, as opposed to a pure legal obligation to provide it.
Yeah.
Oh, that's great. Thank you. And I'm looking at our questions now. I think that we've covered all of them.
Okay.
Let me just check off. Yep, that's everything for us. So I guess it's time for us to wrap up. Amanda, And Mike, did you have any final comments or?
No, I don't have any further comments other than to say thank you to everybody who attended today. And if you have any questions for myself or Amanda or anybody else in our labor and employment group, please reach out and we can help you as you need.
Yeah, absolutely. I echo Mike's comments. It's an interesting time to be an HR professional or a labor and employment lawyer. The workplaces we previously knew are continually evolving, so we're always happy to do things like this or answer any questions that any of you have now or at a later date. So don't hesitate to reach out if something comes up after.
Great. Thanks so much, everybody. Have a great evening. Take care.
Take care. Bye-bye.
Thank you. Bye.